They want to do. Ms. Abraham, who are we ready on?
Mr. Schmidt is ready.
All right, Mr. Schmidt, who would you like to call first?
This is Trevion Bowie.
Can you hear that?
Oh.
Can you hear this okay? Well, I've got to be able to hear it too. Do you have your other speaker down there? Where's yours? That's face. This one.
Can you hear us, Judge?
All right, this is cause number CR 24-198, State of Texas versus Trevion Lakeith Bowie, set for arraignment. Go ahead, Mr. Schmidt.
Judge, we received the indictment. He understands the nature of the charges. Well, his name's correctly spelled out. We'll waive reading and enter a plea of not guilty. Ask for a pretrial date.
All right, Miss Tabraham, will you check the settings on that camera or the microphone? We can barely hear. All right, court finds Mr. Bowie having waived the formal requirements of arraignment, enters his plea of not guilty into the record. Court sets this matter for pretrial. What date do you want, Mr. Schmidt? The 30th or October 14th?
I don't need a lot of time on Mr. Bowie. We're familiar with this stuff, so the next full Tuesday docket, fine.
You say the next, so the 16th would be the next Tuesday docket.
And that's, yeah.
Is that fine? Okay. All right, court sets Mr. Bowie then for pretrial September 16th at 1:30.
Your Honor, is this better?
No, it's not. I've got my speaker at full max over here and we can't really hear much. Which microphone? Is this the new camera?
No,
No,
it's not
sir.
installed yet.
Is the microphone turned on?
It was in a drawer so we could see Mr.
Well, it's on its last leg.
Yeah, but are we using an internal microphone or using that external microphone?
It's the external. It's right here.
Yeah, we can barely hear you.
Your Honor, just to help kind of diagnose, are you able to hear me regularly?
You're a little muffled too.
Ah.
Let me turn things off real quick.
Lord.
Stand by. Let me test on this side.
If I'm gonna have to see, I don't want, if it works, I don't want to waste any time. Judge, can you hear that better?
He turned everything on.
Oh,
This is the comedy hour.
well, we turned something. I could just zoom in on my phone and call it a damn bed because that way it's so good. It's nobody's fault that this is not working, but we have another one we just bought, but yeah, split it already, yeah. Until next week, I could sit right here.
Yeah, or we can use that one if y'all think that one will work better.
Well, you're gonna need that pretty fast.
Oh, that's right.
We'll just have to make it through today.
Well, Mr. Schmidt, so he can switch over to his phone and we'll see if that works better.
I don't know. I mean, I don't hear Mr. Hartwell any better either, so it might be on my end. He's just real muffled and real faint.
Judge, how about now?
No difference here. We'll just move forward. I'll make it through it and I'll figure all this stuff afterwards. Who's next?
This is Morris Moreno.
Court calls cause numbers CR 24-240 and 241, State versus Morris Lee Moreno, set for arraignment. Go ahead.
That's correct, Judge. We have received the indictment. His name spelled correctly. We'll waive reading in both cases, enter plea not guilty. Ask for that September 16th pretrial date.
All right, court finds Mr. Moreno having waived the formal requirements of arraignment, enters his plea of not guilty into the record. Court sets Mr. Moreno for Tuesday, September 16th for pretrial.
Kendrick. Hold down. This is Kendrick Willis.
All right, this is cause number CR 19-211, State of Texas versus Kendrick Willis, set on motion to adjudicate. Go ahead, Mr. Schmidt.
Yeah, Judge, this is a motion to revoke. I was just recently appointed. We're gonna have to ask for more time.
All right, court will set Mr. Willis then on the contested docket, which will be October 2nd. That'll be at 1:30.
Should have a plea for Amber Harris in your queue.
Yes, I did.
Is accept.
Court calls cause number CR 23-161, State of Texas versus Amber Daniel Harris. Ms. Harris, if you'll raise your right hand, I'm going to place you under oath. I can't see your hand. Just best you can. There you go. That's good enough. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
So I do.
All right, thank you. Mr. Schmidt, I don't know why we still raise hands to administer oaths. I don't know if that's a special power or what. I don't know why we do that, but
No, you ain't got a weapon in your right hand, Judge.
That's what it is.
Yeah.
maybe so, maybe so. All right, Ms. Harris, you were previously before the court on November 28th of 2023. On that day, you pled guilty to a Class A misdemeanor offensive assault causes bodily injury. The court heard the evidence and followed a plea agreement that day and placed you on, assessed your sentence at 1 year confinement in the county jail, ordered you to pay a $500 fine. The court suspended that sentence, placed you on community supervision for a period of 2 years. It was during your period of community supervision that the state of Texas filed its motion to revoke your community supervision. They filed that in April of 2025. And in that motion, they have alleged 9 separate counts of alleged violations. Have you had enough time to review those allegations in that motion with your attorney, Mr. Schmidt?
Yes, sir.
Are you pleased with Mr. Schmidt and the work that he's done for you as your attorney?
Absolutely, sir.
Do you have any questions about your plea agreement that you've read and signed today?
No, sir.
Mr. Schmidt, do you believe Ms. Harris to be competent to enter into this plea agreement?
Yes, sir.
All right, and some understanding by looking at the paperwork that Ms. Harris will be pleading true to the counts in the state's motion. The state's recommending that the defendant's guilt be adjudicated, that her community supervision be revoked, that her punishment be assessed at 124 days confinement in the county jail, for which she will receive 124 days credit of time served, and she'll be ordered to pay the balance of her financial obligations, which at this point appears to be $1,065 in reimbursement fees, $270 in court costs, and $500 in fines. Ms. Harris, is that your understanding of the plea agreement?
Yes, sir.
All right, understanding those things, I would ask you at this time, how do you plead to counts 1 through 9 as alleged? Are those counts true or not true?
True.
And are you telling me that those counts are true because what is alleged is in fact true?
Yes, sir.
Has anyone threatened you, forced you, or pressured you to plead true today?
No, sir.
All right, the court will accept the defendant's plea of true to each count as alleged. Mr. Schmidt, any objection to the admission of the defendant's waiver of rights and plea of true?
No objection.
All right, that is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
No, sir.
All right, then based on the evidence before the court finds that Amber Daniel Harris has violated the terms and conditions of her community supervision. The court will follow the plea agreement today. The court hereby convicts Ms. Harris of Class A misdemeanor assault causes bodily injury, revokes her community supervision, assesses punishment at 124 days confinement in the Van Zandt County Jail, awards her 124 days credit towards her sentence, and orders her to pay the balance of her financial obligations. Ms. Harris, once you are released from the jail, if it's before 5 p.m., then I need you to report. I'm going to order you to report to the courthouse here and meet with the district clerk's office and talk to them about entering into some kind of payment arrangement for your fines and court costs and fees. Failure to do so could result in the court issuing a warrant for your arrest for failure to follow that court order. Do you understand?
Yes, sir.
All right. And if you don't get out before 5, just make sure you come on the next business day, okay?
Yes, sir.
All right, Ms. Harris, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you step over to be fingerprinted.
Thank you, sir.
You're welcome.
Thank you. Smith.
Yeah.
Ms. Abraham, our jail interpreter has logged in. Are we ready for jail interpreter? Is that at 2 o'clock?
Is that Holly or is that me?
I'm sorry, I can't hear you.
Is that the OCA or is that, I've logged in as district court interpreter?
Oh, okay. No, then that's you. I'm
Okay.
sorry. That's you. I just saw the word interpreter. Do we need to take a break, Mr. Schmidt?
Yes, sir.
Okay.
We'll
I'm
be
gonna
ready when your interpreter is online. That individual's here and we're ready on him. I've got 2 sets of plea paperwork we've got to do.
Okay, go ahead and do that, Richard, and Mr. Abraham, I've logged you in.
Okay,
Go ahead and call Mr. White's case. All right, court cause number CR 25-13, State of Texas versus Michael Anthony Solis. Court finds that Mr. Solis is still in custody in Tarrant County on a bench warrant from Dallas, it says. Apparently our bench warrant was not honored, and so Mr. Solis has not been returned to Van Zandt County custody. So we'll reset this case, Mr. White, and we'll bench warrant him again and see.
I haven't had just a whole lot of success. And I'm hearing everything pretty much starting in with Tarrant County. Been contacting the DA's office on a pretty regular basis and probably getting pretty tired of me talking to them about it. But I'm hearing everything from they don't have a warrant, that Tarrant at Dallas County has a hold on them first. I even heard one time that ours is expired. I've never heard of anything like that, so any help I can get from the court, I'd appreciate it.
Yes, sir. Court will issue a new bench warrant. Are you available on September 30th?
Yes, I believe so.
All right, court will reset this for arraignment to September 30th at 1:30, and the court will issue a bench warrant for Mr. Solis.
And Your Honor, it's my understanding he may be set to catch chain here pretty soon, within the next maybe week or two. So that may be why Tarrant refused to honor it, is they didn't want to miss that window.
Did you hear that, Mr. White? Mr. Hartwell indicated that Mr. Solis may be on his way to TDCJ, and that may be the reason that Tarrant County didn't want to honor the bench warrant, because they've already requested a ticket for him to be transferred to the Texas Department of Corrections.
I heard that one too.
So if that's the case, we may have to wait for him to get wherever he is going in TDCJ and then issue a bench warrant then. But we'll inquire. I'll have Mr. Abraham inquire at Tarrant County.
Okay, thank you.
You're welcome.
Just leave the city.
Yeah, you just see that. All right, court's going to stand in recess and give Mr. Schmidt some time to speak with his clients.
Reiner?
Yes, ma'am.
Okay.
Hi, Holly. Can you see and hear me okay? Yes, ma'am, I am. How are you doing today? Okay. All right. Holly, before we get started, if you'll raise your right hand and state your name and license number, I'm going to place you on oath. Ms. Bill, do you solemnly swear or affirm that you will make a true translation of the statements of court, the questions of counsel, and the testimony to be given by the witness in the matter now on trial to the best of your skill and judgment? So help you God. Thank you. All right, court calls cause number CR 25-166 and 167. This is, and also 168, my apologies. This is the state of Texas versus Orban Ariel Martinez Arazo. And we are set for arraignment today in all three cases. The court recognizes the Honorable Richard Schmidt as counsel for Mr. Martinez Arazo, and he is appointed by the court. Go ahead, Mr. Schmidt.
Yes, sir. If you'll bear with me, I'm gonna be a little bit more long-winded than normal. In CR 25-166, Mr. Martinez Arazo is charged with a third-degree felony of evading arrest with a detention with a vehicle. And then CR 25-167, he's charged with abandoning or endangering a child, which is a state jail felony. At CR 25-168, he's charged with prohibited substance in a correctional facility, a third-degree felony. His name is spelled out correctly, and we would waive formal reading of the indictment at this time and enter in pleas of not guilty to all three charges and ask for pretrial settings.
All right, the court finds that the defendant, having waived the formal requirements of arraignment, enters his plea of not guilty to each charge in the record. The court sets the defendant for pretrial hearing. Did you have a specific date request, Mr. Schmidt? I didn't hear you.
Judge, because of the language barrier, I have to be able to squeeze my interpreter into the jail with me to talk to him over the discovery, so I would request additional time or more than normal.
You want that October 14th date?
Yes, sir.
All right, court sets the defendant for pretrial hearing October 14th in all three charges. Mr. Schmidt, do you want me to inquire as to whether the defendant has any questions that he can ask you in a private breakout room with Miss Beal? She's relieved.
Yes, sir, that'd be fine.
Miss Beal, do you have any time availability for just a few minutes? Okay, so what I'll do is I will send, let's go ahead and do that at this time, Mr. Schmidt. I'll go ahead and send each one of you an invite to a breakout room. And then Ms. Bill wants, if there are no further issues that need to be placed on the record, Mr. Schmidt, then just let Ms. Bill know so that she can exit and go about her business. If we do need to put something back on the record, let me know. Y'all return to the main session and we'll do so.
Yes, sir, thank you.
And Mr. Schmidt, just be mindful, she is scheduled for very specific time allotment, so.
And yes, sir, we're in a public place, so the questions will have to be non-specific, but I do appreciate the opportunity.
Okay, yeah, I'll go ahead and do that at this time.
Who can put me in?
Thank you, Holly.
Right there. Over there? That's fine.
We'll see which one comes up. Holly, can you hear us?
Richard, you'll need to do it on your side too. That way Holly can translate simultaneous for both of y'all. So both of y'all will enter into that breakout room.
Got it.
Holly, We've been over on the breakout room waiting on you.
Oh, I was not there.
No, you were.
I was not there in the,
We kept talking to you and
yeah, judges are not allowed in those kind of breakout rooms. So, you ready, Mr. Banda? All right, court calls numbers CR 25-63 and CR 25-190, State of Texas versus Oscar Fabian Banda. Mr. Banda, sir, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. You have to say something. You can't shake it. And we're having some technical difficulties today, so it's very hard for me to hear. So just make sure you speak up as loud as you can. Okay. All right, Mr. Banda, are you a United States citizen who reads, writes, and speaks English?
Sure.
And have you ever been diagnosed with a mental condition?
I'll say,
No? Let's see. Ms. Abraham, we're gonna have to do something else because I can't hardly hear anything he's saying. I don't know what we're gonna do, but
tell him,
I don't think it's y'all's in, but I've done everything I can over here and I'm not picking up anything he's saying.
I'm gonna try him out now on Zoom tomorrow and see if it's better.
And let me ask, Mr. Hartwell, are you able to hear them better? Is it normal for you?
Your Honor, I can hear Mr. Schmidt. I was unable to hear Mr. Banda though, so it may be where the microphone is located, or if they're using the portable versus the in computer.
Maybe just unplug that microphone, plug it back in. Let's make sure that it's routing to the right input.
6-5 what?
one. We let Mr. Smith in on his cell phone and we're gonna see if perhaps.
Let me try something. Mr. Bandit, just say something for me. Say your name.
Oscar Bandit.
Okay, I think we'll get through with it. I'm just gonna put my microphone on my speaker. Can y'all still hear me okay?
Yes.
Okay. All right, Mr. Banda, have you ever been diagnosed with a mental condition?
No. Oh,
And in this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt and the work he's done as your attorney?
sir.
And do you have any questions about any of the paperwork that your plea agreement that you've read over and signed today?
No, sir.
Mr. Schmidt, do you believe Mr. Bandit to be competent? If so, do you believe that he's entering into this plea agreement intentionally, knowingly, and voluntarily after being fully admonished and informed of his rights?
Yes, sir.
All right, Mr. Banda, I see that. Let's take my paperwork to pull up there. Mr. Banda, I see cause number CR 25-190. You have been charged with the offense of continuous violence against the family. And Mr. Schmidt, Mr. Hartwell, the judgment says that he's pleading by information.
That's correct, Judge.
Is there a waiver of indictment?
It's contained in the plea admonishments, Judge. We've waived within the plea admonishments in that document. There's no independent waiver of indictment.
Okay. Mr. Bandit, do you understand that you have the right to have this case presented to a grand jury for them to determine whether or not they believe that there's enough evidence to proceed in the case? Have you held over for trial? Do you understand that?
Yes, sir.
And you understand that you are the only one that can waive your right to a grand jury indictment. You understand that? Are you asking the court to allow you to waive your right to a grand jury indictment and to proceed this case by allowing the state of Texas to file this case formally against you by information rather than by indictment.
Yes, sir.
I see that upon your plea of guilty to the charged offense of continuous violence against the family, that is a third-degree felony that does carry a range of punishment of not less than 2 years in prison, not more than 10 years in prison, and a possible fine not to exceed $10,000. Plea agreement appears to be upon you pleading guilty, the state's recommending that your punishment be assessed at 10 years confinement in prison. Also a fine of $2,500, restitution in the amount of $2,640.39, court cost of $290, and reimbursement fees of $15. You would also receive credit towards your sentence for any time that you spend in jail on this cost. At this point, Mr. Schmidt, what is the credit time for Mr. Vando?
Oh, just a moment, Judge, I'll pull it up for you. I mean. Got 197 days, Judge.
197.
Yes, sir.
All right, so Mr. Vando, you would be entitled to 197 days credit towards your sentence. So, Mr. Vando, understanding the range of punishment, understanding the plea agreement, at this time, I would ask you, how do you plead to continuous violence against the family? Are you pleading guilty to that offense because you are guilty of committing that offense?
Yeah.
Okay, and Mr. Vando, has anyone threatened you, forced you, or pressured you to plead guilty?
Oh, sir.
All right, the court will accept the defendant's plea of guilt. Mr. Schmidt, any objection to the evidence?
No objection.
The evidence is admitted and the court takes judicial notice of the defendant's judicial confession. I also see that part of this agreement, the state is filing or has filed a motion to dismiss and cause for CR 25-63, which appears to be the charge of attempted murder. And what about, let's see, is that the only, those are the only two charges that Mr. Vanda has this time?
Those are the only two filed charges, yes, Your Honor.
All right, anything further from the state?
Your Honor, there should be a victim impact statement with the court. If not, I can get a copy over to you. Other than that, state is in compliance with victim services.
Yes, I do not have a copy. Let me double check my notebook here, but I don't believe that I do have a copy. Do you have one scanned in your system that you could display? So the court can review that before I pronounce things.
Let me see if I do, Your Honor. If not, I can have one emailed over. I know it would take a little bit of time. Your Honor, I would have to have one emailed over to you. I can get that done in the next just a couple of minutes here.
Okay, let's go ahead and do that because I need to review it before
Yes, sir.
process this. Mr. Schmidt, anything further from the defense?
No, Judge, just that Mr. Hartwell said these are the only two charges that the state has filed. It's my understanding that this was the only charge that he had pending against him. I wanted to make sure that there were no unfiled Van Zandt County charges that haven't been resolved with this plea as well. In other words, we don't want any unfinished business. I don't know that there is any. I didn't think there was. But other than that, nothing.
And Your Honor, there are a couple of other unfiled misdemeanor cases. If those were not included in the judgment, then we can definitely make sure that we get those included.
So you're gonna formally reject those?
Yes, Your Honor.
Court will note for the record that
And for the record, Your Honor, those would be DA control number 2025-177, 179, and 180, which is a resisting arrest, an interference with emergency request for assistance, and a misdemeanor level unlawful restraint.
Are you satisfied with that, Mr. Schmidt?
Yes, sir.
All right, court will note for the record that the state part of the plea agreement is agreeing to reject those aforementioned misdemeanor unfollowed misdemeanor cases. All right, the court's going to review the evidence.
And Your Honor, those should be on their way to you. I still have to create a tracking sheet for you to sign, but the document should be on its way.
Well, if you just want to send over, just email it over, I can sign it later. This will be good enough for me to review it.
Yes.
And I have it, I'm going to review it. Mr. Hartwell, the only issue I have a question about is there was a claimed restitution tax statement of $20,000. Has that been?
Yes, Your Honor. The that restitution included multiple different items. What we could track for what would actually qualify for restitution, the amount that's in the judgment is for the medical bills, which was the only claim that we were able to verify as actual restitution. The rest of the claimed amount would have to go through a civil process.
Okay, very good. All right, the court having considered the victim impact statement evidence, the court finds that there is enough evidence to convict the defendant of the offense. The court follows the plea agreement. Court hereby convicts the defendant, Oscar Fabian Banda, of continuous violence against the family, a third-degree felony. The court finds that Mr. Banda has intentionally, knowingly, voluntarily waived his right to an indictment, has had the assistance of counsel in doing so. Court follows the plea agreement, accepting his plea of guilty, assesses punishment at 10 years confinement, The Texas Department of Criminal Justice orders him to pay a $2,500 fine. Restitution in the amount of $2,640.39 and court costs of $290 and reimbursement fees of $15. The court awards Mr. Vando 197 days credit towards his sentence for the time that he spent in jail on this cause. Mr. Vando, you hereby remanded to the custody of the sheriff so to carry out the terms and conditions of the sentence. I'm gonna have you step over to be fingerprinted. Once you're released from TDC, you need to make arrangements to pay your fines and court costs. And for the record, the court is also granting the state's motion to dismiss and cause number CR 25-60. That has been signed. All right, so, Mr. Ho, this is cause numbers CR 24-233, 234, FC 24-146, State of Texas versus Mason Edward Ho. Mr. Ho, sir, if you'll raise your right hand, I'm gonna place you under oath. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. Well, all right, Mr. Hogue. Are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with him as your attorney and the work that he's done?
Yes, sir.
Do you have any questions about the paperwork that is your plea agreement that you've read and signed?
No, sir.
You have a question about anything else before we proceed further?
No, sir.
Mr. Schmidt, do you believe Mr. Hogue to be competent after having explained to him his rights regarding the case? And all the other issues surrounding his plea charges?
Yes, sir. I do.
Okay, Mr. Hogue, I see that you are charged by indictment in CR 24-234 with a third-degree felony offense of unlawful possession of a firearm by a felon. That does carry a range of punishment of not less than 2 years in prison and not more than 10 years in prison. Your plea agreement appears to be, upon you pleading guilty, the state's recommending that your punishment be assessed at 3 years confinement in prison, a $1,500 fine, restitution in the amount of $2,723.88, court cost of $290, reimbursement fees of $20. Further, there would be a agreement to dismiss or take into consideration some unfiled charges, those being evading arrest or detention with a previous conviction, fraudulent use or possession of credit card or debit card, criminal trespass, criminal mischief, and dismissal of your filed charges, possession of a controlled substance, a third-degree felony, and burglary of a building, a state jail felony. There's also an agreement included here that you would be forfeiting a 380 Ruger that was seized as in connection with the offense. Mr. Hogue, is that your understanding of the plea agreement?
Sir.
All right, understanding the plea agreement and the range of punishment, how do you plead to the unlawful possession of firearm by a felon and third-degree felony?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened you, forced you, or pressured you to plead guilty?
No, sir.
Court accepts the defendant's plea of guilt at this time. Mr. Schmidt, any objection to the evidence?
No objection.
All right, the evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
No, sir.
The court will consider the evidence. All right, the court, having reviewed the evidence, finds enough evidence to convict the defendant of the offense. Mr. Schmidt, how much credit time is Mr. Hoag entitled?
376 days.
376?
Right.
All right, the court. Having reviewed the evidence, finds enough evidence to convict the defendant of this offense. Court follows the plea agreement. The court convicts Mason Edward Old of third-degree felony offense, unlawful possession of firearm by a felon, assesses punishment at 3 years confinement in the Texas Department of Criminal Justice, orders him to pay a fine of $1,500, restitution amount of $2,723.88. Further, the court forfeits the weapon seized in regards to this offense as outlined in the court's judgment. The court dismisses those offenses that are unfiled, previously stated by the court on the record. Court orders Mr. Hoag to pay court costs of $290 and reimbursement fees of $20. Court hereby awards Mr. Hoag 376 days credit towards his sentence for the time that he spent in jail on this cause. Mr. Hartwell, Mr. Schmidt, is the restitution amount on the judgment, does that include the 180 restitution? Or are those separate amounts?
Your Honor, I believe it's the two separate amounts, the 180, and then the residual would go to the unfiled, the restitution in one of the unfiled cases.
Okay, I just see that in the terms of the plea bargain, we only have restitution stated for the $180. We don't have restitution stated for that owed to John Mitchell. So let me put that on the record. The court orders, as part of the plea agreement, restitution owed to Mr. John Mitchell as laid out in the court's judgment, the amount of $2,543.88, and then orders restitution owed to the Texas Department of Public Safety for testing of the controlled substance in the amount of $180 for a total restitution, as previously stated, $2,723.88. All right, Mr. Hoag, you hereby remain to the custody of the sheriff so you can carry out the terms and conditions of the sentence. Mr. Hoag, once you're released from TDC, it's important that you pay your fines, court costs, and fees. If you do not pay all of these off while you're in prison, then when you get out, you need to make arrangements at the Van Zandt County Courthouse and the district clerk's office. Failure to do so could result in you being rearrested for failure to follow court order. Understand? All right, please step over to briefing.
Thank you.
All right. Guess we're done. Jail just disappeared on us.
I think so, Your Honor.
Oh, wow, okay. Guess they're ready to be done over there. I guess that concludes our business then in court. We'll be adjourned. Did you get that message I sent you, Mr. Harwell?
I did. Thank you, Your Honor.
Okay. All right. Appreciate you, sir. Have a good day.
Absolutely. Thank you, sir.
You welcome.